to you in a little bit. He's been a partner in our litigation group for 28 years at this point, and he specializes in servicing the staffing industry, staffing companies, manufacturing and service industries. And I've been partners with him since we started this firm 20 years ago. Also in the room with me is Brian Kelly. He's the chair of our firm's labor and employment practice groups, and he has been named to the prestigious Chambers Leading Lawyers in America for the employment and labor section. So obviously Brian is going to be talking to you about the employment questions that we've been fielding here in the last, I'm going to say 10 days. And Chris Koehler is very familiar with the insurance issues that are going on, and I'm going to focus more on the construction contracting issues that folks are calling us for and asking us questions. Thanks. So the first thing is delays. What happens when we have a delay here? Do you get an increase in contract time? Do you get an increase in contract sum? Do you get both? What exactly is going to happen? That's the question. And I think what I want you all to have for takeaways here is that, and you'll see this as we go through the slides, the AIA and consensus docs allow for extra time, but not cost. That's going to be the upshot of what this presentation is here, at least my section. The second takeaway is provide written notice. You all already know that. I've given many seminars on that, including with the CEA, how to provide notice, what you need to provide. This coronavirus is no different. You have to give notice to the owner, to the design professional, to make sure they understand what's going on and they have the opportunity to mitigate. If you do that, no one is going to say that it's your fault or try and take away that claim from you at the end of the day. Finally, we haven't gotten to this yet, but there can be termination options for the contractor. As all of you know, those are very few and far between. The grounds for termination from the contractor end of things, as opposed to what the owner can terminate the contract for under the AIA and consensus docs. So those are the takeaways, at least from my presentation. You'll see here, first I want to talk about the A201 2017 force majeure clause. And in my almost 30 years of doing this, I have never negotiated a change to the force majeure clause, and no one really ever pays attention to it. So these are unique times that we find ourselves in dealing with force majeure clauses. These are designed under any of the family, the AIA family, consensus doc, and other families of contracts. They're designed to deal with unforeseeable and uncontrollable events. The classic examples are natural disasters like earthquakes, hurricanes, floods, tornadoes, wildfires when you get out in California, that type of thing. The case law interpreting them focuses mostly on those natural disasters, but also on some man-made problems such as civil and military disturbances. Terrorism is a big one, explosions and strikes. The reason that these force majeure clauses are important in our construction contracts is because without it, the risk would fall back on us. The risk without this clause of exactly what's happening here, when you have workforce shortages and the other impacts that are being caused by the coronavirus, the risk is on us to get things done, to meet our deadlines, keep the schedule up, avoid our liquidated damages, and properly and timely perform the work. Without this force majeure clause, if it came up and if and when you all called us, and for example, if you were working under a private oral contract or something like that, we would have to fall back on pretty esoteric discussions of impracticability and frustration of purpose. So it's good that we have these force majeure clauses in these contracts. And the first one that we have is the delay and extension of time in the A201 2017. And I've highlighted the important parts of this clause. you can get extra time for causes beyond the contractor's control. And obviously this is all dependent on the cause of the delay not being your fault, not being the contractor's fault, and not being the fault of any of your subs, suppliers, or material men. So that's number one. It has to be a cause beyond the contractor's control. And if it is, then you're in the game for getting extra time. And then you can see that's subsection 3. Under subsection 5, by other causes that we assert and the architect or the design professional on the job determines justify the delay. That gets you a day-for-day extension as the architect or design professional determines is appropriate. So my advice, and I've given this out in the last few weeks here, is give your notice to the owner, give it to the architect, and seek to get the architect on board, seek to get his or her approval and authorization and acknowledgement of what's happening, that there is a delay and that the extension will continue unless and until the architect says otherwise.
Mark, can I just interrupt for a second? This is Chris. And I don't do much construction work, but I do a lot of commercial contracts. And these same principles are going to flow through in your standard terms and conditions that you might have with suppliers who aren't dealing with the AIA forms. So look to see if you've got a force majeure clause in those contracts and follow those to the T. But even if you don't have a force majeure clause in those contracts, it's a good idea to put people on notice as if you do have one, because we may be able to take advantage of some, as Mark said, impossibility or impracticability theories to get you some relief from your contracts.
Good point. Could you advance this one for me? Sure. Thanks. So the next slide is the consensus docs 200. You can see there, it's very similar. It gives time. I've taken out a lot of the examples that are listed after the initial sentence there, but I've highlighted the critical ones. They are epidemics that we're dealing with and adverse government actions. The consensus docs goes on in this section of 6.3 to state that you can get additional costs, but it's only for items A through D. And A through D are delays chargeable to the owner and or the design professional. So in the coronavirus situation, these are not going to come into play. So under both, as you can see, you're going to get a delay, but you're going to get time for the delay, but you're not going to get any extra costs. Of course, with the caveat, if you're working under a cost plus without a GMP, then definitely track your costs and make that part of the notice of your claim as you develop your claim moving forward. So the next slide here is relative to notice requirements, and for those of you that have heard my my pleadings and my presentations at other times, we have to give notice. And based on the case of Dugan and Myers, I'm sure everyone's familiar with that. That's from 2007, Ohio Supreme Court. Courts in Ohio and arbitrators, frankly, because I'm a AAA arbitrator as well, we take these notice provisions very seriously and will enforce them. So notice provisions in Ohio under Ohio law are strictly construed, and failure to comply with them is going to result in the waiver of your rights and remedies. And if you step back for a minute, why is that? Notice is very important, and courts and arbitrators enforce it because it is the mechanism that gives the owner, who's ultimately footing the bill, the opportunity to analyze and put into place whatever he or she deems best to mitigate the problem, mitigate the damage, and move the project forward. So again, if you fail to give the proper notice requirements, you're going to waive your rights and you're going to lose those rights. So this slide is generally what you need to do, but for those of you that have heard from me before in terms of best practices is you or someone in your company is going to go through the contract. They're going to create a one-page cheat sheet with the claim and notice requirements, timing requirements, substantive requirements. What do you have to provide to comply with the contract requirements? They're all different. We're going to see that in a minute here as we go through AIA and the consensus doc. But for those of you that do public jobs, you know that those are very, very stringent and very specific in terms of when you must provide information upstream to the public owner and what you must provide upstream to the public owner. But that's for a different day. We have limited our analysis here in our discussion really to AIA and to consensus docs. So this first slide, I'm sure a lot of you are familiar with. This is the AIA notice requirements. It's under Article 15, and again, we're in the A201. We're not in the associated document, typically the A133 or the A134, whatever it would be. But as you all know, the A201 general conditions supplements and goes with many of those documents. So under the AIA, you have 21 days after you knew or should have known that there was going to be a delay to give notice to the owner. The consensus doc is a little bit different. So if you are working under the consensus docs, you have to give prompt written notice to the owner. There's an interesting interplay here that I hadn't looked at before with Article 6 of the consensus docs and Article 8. They kind of play back and forth with each other. But my analysis is that notice of any force majeure, or in this case, the coronavirus delays, you have to give prompt written notice, and there's going to be no time frame on it, but you should do it as soon as possible. Usually for delays, you have to give notice within the 14 days and then supplement within the 21 days. And when you're supplementing, there's a variety of things that you can supplement with as you're putting the owner on notice, and you're quite possibly working with the owner in order to mitigate the delay and get through things as quickly as possible. Some of the things that you're going to be looking at are schedule updates, look-ahead schedules, progress meeting minutes, daily and weekly reports, photographs, job diaries, cost coding, anything like that that's going to give the owner an idea of what's going on, the owner and the design professional, an idea of what's going on, and to really round out claims. So you can see that those documents are really more for when you have a discrete event that's causing a delay, late shipment, design defects or late designs or other things that are going to be chargeable to the owner and to the as a result of what the owner's design professional is doing under a typical design bid build. You know, obviously that's not true if you're under a design build contract. But here, you know, it's not so important, I don't think, to have that, but you will have to put estimates together of impacts of how cost escalation is going to impact the costs, your costs, and how basically labor shortages are going to impact what you're doing, etc. And the flip side of this is these notices are to protect you from liquidated damages if you have that, or other types of penalties for late delivery. These are the notices that will get you out of those types of penalties at the end of the contract. So consensus doc, just a little bit different, 14 days to give notice and 21 days to supplement. Those are good guidelines, but I do think that if you get right down to it, those won't be fatal, even though what we had earlier discussed about Dugan-Myers and courts in Ohio really strictly construing these notice provisions. So that's as far as we've gotten in terms of questions from the clients. There is a related one, and that is termination by the contractor. And you know, as you will see here, the AIA and the consensus doc are very similar. If the work is stopped for a period of 30 consecutive days, the contractor, upon 7 days written notice to the owner, can terminate the contract. Okay? And then I'll get to what your damages are in that scenario in a slide or two here. But the first one is the issuance of an order of a court or other public authority having jurisdiction that requires all work be stopped. And the second part goes on to the next slide. An act of government such as a declaration of national emergency that requires all work to be stopped. Sounds very familiar, right? That sounds like, hey, maybe that might be happening here. And if you're having a bad job, maybe you could use this if work is going to get stopped to get out of it. So having heard that from our contractor clients, I will caution you at this point, because the law to date, what we have in Ohio is we have Governor DeWine's executive order from March 9th. It's called Executive Order 2020-01D, if you want to look it up. That was issued March 9th, and that basically declared the emergency, the health emergency in the state of Ohio. Following up on that, where the law is coming from, Ohio law on this issue, is it's being issued from the Ohio Department of Health. Their director, Amy Acton, has issued several directives from her office. The first was, and this is the law, okay? So on March 12th, she prohibited mass gatherings in the state of Ohio, which were defined as 100 people or more in an enclosed area, inside or outside. And they specifically excluded factories and businesses, offices like the one I'm in right now, where folks aren't typically coming into arm's length contact with each other. Then we all remember this, on the 15th, she closed down all the restaurants and bars. And then on the 17th, she changed the definition of mass gatherings to 50 people or more. And the recommendation is avoiding gatherings of 10 people or more, right? So that's very interesting for us in our profession, because do we or do we not fall under the 50 people or less? At this point, I don't think that we're falling into it, but I've taken kind of the easy way out in advising some clients, because we have job sites where there's not 50 people, right? It's underneath that threshold of 50 people, even though they're all in an area. You know, you've got the, you know, if you're dried in, you're going to have HVAC, electrical, and other folks in that area, in that enclosed area. But so far, until she brings it down to 10, I'm not advising contractors yet that they have the ability to send this 7-day notice of termination up to the owner, because of the state of Ohio law. And federal law, they seem to be issuing recommendations, and the CDC seems to be issuing recommendations that are not law. So that's, I think that under the AIA and frankly the consensus docs that we're going to get to next, you need some type of order that's going to prevent work or stop work, and we don't have that yet. As an aside, in Boston, they do have that. They do have an order shutting down job sites. So I think unless and until we get there, if you're having a delay, definitely put the owner and the architect or design professional on notice of the delay. But I don't feel comfortable yet advising clients that if they want, that they can terminate existing contracts based on what we've seen so far coming out of the Ohio Department of Health. So that's the A201. And again, it's 7-day written notice. And what you can recover is basically for the work that you've executed properly and timely, and then reasonable overhead and profit on the work that you haven't been able to execute because of the emergency. And then that last phrase, costs incurred by reason of such termination, that's going to be demob costs, and then any subcontract costs that you get stuck with when you're trying to terminate downstream for convenience, whatever your subcontract says with your lower tiers. So consensus doc 200, you'll see it's pretty much the same thing, 7 days written notice. To the owner, you can terminate the contract if work's been stopped for 30 consecutive days and it's not your fault. And it's very similar, this language, under court order or order of other governmental authorities having jurisdiction, or as a result of the declaration of a national emergency or other governmental act during which, through no fault or act of the constructor, materials are not available. So very similar. And then you can see the damages available to you upon such termination are pretty much the same. Payment for work timely and properly executed, overhead and profit on the work that you're not able to perform because of the emergency, and then demobilization costs. So very, very, very similar there. So that's the end of my section. I'm going to turn it over to Chris to talk about insurance.
Thanks, Mark. Mark and Brian later will be telling you a lot of ways that you guys will have money going out the door because of this crisis. Hopefully, I'll give you some tips as to potential ways to get some money coming in the door through insurance, if you have the right insurance. As a general rule, most policies don't have the type of an insurance that would cover a business interruption. That's as a general rule. Most commercial, general, or CGL policies don't have that coverage. However, a lot of policies, either people buy an additional policy or they get an endorsement in their CGL policies in which you can get business interruption coverage. So it's important to recognize that you may have the coverage and not know about it. Other ways to get insurance coverage or other avenues, some policies have what's referred to as civil authority coverage, where you, if there is an order from the government requiring curfews or shutdowns, like the kind of orders that we're starting to see, and it causes you some kind of loss. A common one would be where there are blockades or curfews set up. Restaurants might have coverage for that, civil authority coverage or civil action coverage. So that's another avenue you might have. A third one is, and I'm not sure how many of you would have this, but there are things called all risk policies, which are very broad policies that essentially cover any risk you might face except those that are specifically excluded. Those are very broad policies, probably very expensive. And if you have those policies, you could probably shoehorn coverage for the business interruption that you're facing into that policy. And I'll give you a specific example of that in a bit. And then fourth, there are contingent business interruption policies where the business interruption isn't your own. It's not because you have crews that you can't put out there on a site, but your supplier in China can't get you the materials you need to perform your work. So your loss or your business interruption is contingent upon the interruption that your supplier in China faced a few weeks ago. So those are the type. There are policies that are available for business interruption, and there's a number of methods to get there, but you've got to see what your policies might provide. And so the biggest takeaway of this is you should be in constant communication with your broker. That's what you pay your broker for, to puzzle through the policy with you to see what you might have and what you might be able to take advantage of. So if I could leave you with anything on the insurance issues, it's talk to your broker. That's what they're there for. Sometimes, and the broker should be looking at this, even if you do have business interruption policies, sometimes there are specific exclusions for things like outbreaks. That came into vogue, for instance, after the SARS epidemic in the early 2000s. So you'll have to see whether somehow an outbreak or an epidemic is specifically excluded. Hopefully not. These policies, particularly on business interruption, have specific requirements. Just because you have a business interruption policy or endorsement doesn't mean you're automatically going to get coverage, because quite often these coverages cause or require that there be some physical damage. Mark gave you the classic examples of tornadoes and hurricanes and things like that. That's very obvious physical damage. If the building or the job site is leveled by a tornado, then that's going to be easy to trigger coverage. Some people have worried in this circumstance with the virus that they won't be able to prove that physical damage requirement, but some creative people down in Louisiana filed the first lawsuit over this just yesterday, saying a restaurant filed under an all-risk policy and said, because the virus can live on surfaces and the restaurant was essentially rendered unusable because of the virus being on surfaces, that's physical damage that will trigger coverage under one of these policies. So people are being very creative about how to reach this physical damage requirement. And I think this will evolve, obviously, in the next days and months and probably years to come. But I think we might be able to get around that physical damage requirement. It's also interesting to note that even if you don't have a business interruption policy, we'll keep on top of what governments are doing. The New Jersey legislature suggested yesterday that they are going to try to get through some kind of act that compels insurers to cover business interruption, even if there's no policy in place. It seems absurd to me, and I don't know if they'll be able to do that constitutionally, but legislatures are going to start getting aggressive about trying to help people out who are interrupted by this. So we'll keep on top of that, but keep your ear open for that. If coverage might be available, even if it just might be available, there's a couple steps you should take. First, always provide notice to your insurer. Just like Mark was indicating, you should provide early notice on the force majeure issues. Provide notice. If you don't provide notice and you have a claim, you've essentially waived it, and that's an easy out for the insurance company. So provide notice early and often. And then second of all, maintain the kind of information you'll need to support a claim for business interruption. You're going to be claiming maybe lost income, expenses. If you've got people that are being forced to work remotely and you're having to rent space or purchase equipment for them, those are the kinds of expenses you might be able to claim. So make sure you're collecting all that information and maintaining it, so when it's time to make a claim, you're prepared to do it and you can get the full amount. As I said, this is not easy because not everybody has these policies. You should call your broker. You should call your broker. You should call your broker. That's what you're paying them for, and they'll help you work through this. And they can look at your policies. They can they see these all the time, and they're probably getting calls all the time. So you should be one of the people in line to call them and see if you can get some money back for all the money that's going out the door because of what you're losing. So that's insurance. Brian is going to talk about employment issues.
Thanks, Chris. I'll be as quick as I can. We appreciate Tim and his team inviting us to talk. I've spent essentially the last 9 days since this all blew up doing nothing but providing advice to employers about the many corona-related issues that are impacting the workplace. It is important, and I'm sure everybody has seen articles and heard about some of the bills that are working their way through Congress, and people have been asking me, what do I need to do to modify my sick leave policies, my attendance policies, and everything else? My advice to them right now is, in light of the pending bills that you see listed on the screen there, don't make changes yet. As recently as 10 o'clock this morning, we got some information from the U.S. Senate that they're requesting certain changes to the bills, and they're going to be a moving target for a little while now. The basics of it, in case you haven't seen or read it on the paper, is Congress is trying to enact a couple different laws that will apply to employers that have essentially under 500 employees. There are some exemptions. If you're an employer that has less than 50 employees, you can ask to be exempted from the statutes if you can say that complying with them would jeopardize the viability of your business. But generally, anybody under 500 employees is going to have to comply with these if they go into effect. The first was a Paid Family Leave Act, which was somewhat like the existing FMLA. And the idea was people can take job-protected leave. That is, they can take time off. The job has to be there for them when they come back. And they can take it off for a period of time if they need to be off work to care for children because a daycare or a school is closed because of something like the virus. They would be entitled to pay up to $200 a day in that type of situation. There are some tweaks being proposed on that, but that's the first aspect. The other main one is with the paid sick leave law that Congress is trying to enact, and that would allow employees to take up to 80 hours of paid sick time in addition to whatever sick time, PTO, or anything else employers have on the books. And employees could use this paid sick time if they themselves are sick, or if they are ordered to quarantine by the government, or if they're told to self-quarantine by a doctor, if they're seeking medical diagnosis, or if they're off to provide care for somebody else. And there are different caps that would apply to those. There are some proposals to give employers some payroll tax credits, so the employers don't have to bear the full cost of that, but that also is being debated, and it's not quite clear what's going to go through. Or there were some headlines last night suggesting that a Senate vote is imminent, but that does not appear to be the case right now. So just keep in mind that you may need to make some adjustments. If one of these laws passes, I expect it will be a very quick effective date, so the turnaround time will be there. And the importance from the employment standpoint is it can provide protection. So if someone says, I'm not coming to work because I think I had a high risk exposure, or I have to take care of my kids, then they have to have their job protected if one of these laws goes into effect, as the bills are currently written. So don't panic now, don't start making changes, but be aware it's something that you should pay attention to, and if it goes into effect, get some advice from someone who's familiar with it. On the legislative front, you've probably also seen, or if you haven't, the state of Ohio is essentially going to do away with any standards that would otherwise apply for people to get unemployment if they lose their job. So if they're sick, normally you couldn't get unemployment if you're sick and you're not actively seeking work, or if you're off to take care of a family member and you're not actively seeking work. Ohio is going to suspend those rules largely and say that if you're off for those types of reasons, you can get unemployment benefits. There are also going to be some provisions to try to help employers that if there is a business shutdown, somebody's got to close up all or part of an operation. Clients have been concerned saying, is that going to hammer me on my unemployment costs? And what the state of Ohio has decided to do is, if a business or part of business has to be shut down for a reason like that, they will take the unemployment costs and put them into what's called a mutualized account. So instead of your account, it gets shared across others. So certainly something potentially favorable. So that's some of the developments there. I know this is not the primary audience where you have a ton of people working remotely, because Mark has already told me, obviously you're concerned more about job site issues, but to the extent you have front office people or others who are going to work remotely, there are a lot of legal issues and traps. And I point these out because I heard as recently as this morning, a lawyer who represents employees was being interviewed on the radio, and the lawyer was explaining all of the claims that person thinks are going to be brought against employers by employees who have had issues relating to this. So any period of goodwill and we're all in this together is going to get thrown out the window quickly, and there will be lawsuits. So a little prevention is worthwhile. So from a remote work standpoint, just a couple things to go through quickly for you here. And some are practical, some are legal. I absolutely recommend that if you're going to let people work remotely, that you put some limitations on where they can do it. Although here in Ohio, obviously people can't take off, go to a bar, restaurant, library, rec center, or anything else to do work. We've still seen situations where people need to get the heck out of the house because the kids are home or something else, and you end up having people logging on to unsecured networks, and we're seeing data security issues already. So that's one aspect to put in place. Two, define the expectations for when. We've had people on the employee side to say, okay, I'm being told to work from home, so now I'm going to work early, late, whatever it may be. And the wise employers are saying, if you have a need for somebody available during your business hours, make that clear at the outset. Tracking the time and the amounts to be paid. If you have hourly employees who are working from home, you're required to pay them, of course, for any hour they work. And so you should require them to accurately report the time they spend. You don't need someone saying, I worked from the minute I got up to the minute I went to bed, and you end up getting a big bill for it. So you track it. You can keep an eye on productivity too. As I said, technology, data security, things to take care of. reimbursement for remote working expenses. Here in Ohio, you don't necessarily need to reimburse someone if that person says, well, I'm working from home, so my internet costs have gone up, or I have extra cell phone charges, something like that. If you operate in other states, you want to be careful about that. For example, if you do any work in California, California has a very strict law that employees need to be reimbursed for all business expenses, and they can be broken down to virtually anything. They're using a home printer, printing on their paper, they have to be paid. So keep in mind that. Believe it or not, from the workers' comp standpoint, if someone is being told to work remotely and they trip over the coffee table, fall and get hurt at home while they're working for you, it can give rise to a workers' comp claim. People say, what the heck am I supposed to do, go inspect somebody's home? No, but it's not a bad idea. If you're letting people work remotely, ask them just to confirm for you that they've set up a workspace that's safe and secure and that that's where they'll do their work. So then if they get hurt because they're walking the dog while taking a call or whatever it may be, you can say they went beyond the scope of where they were supposed to be, and you can have certain types of defenses. Some of the most common questions we've been getting over the past week deal with whom do I need to pay and when do I need to pay them? And there are two key aspects of that with all this coronavirus stuff. And one is what the legal requirements are, and two is what is going to be least disruptive from a morale standpoint. And you'll see on the slide, I won't spend a ton of time going through all of the most common scenarios. If someone's off, the first two there, because an employee says, I'm sick, I can't come to work, or you send somebody home saying, you're sick, don't come to work, there isn't a legal requirement to pay those people, unless, of course, one of these new bills goes into effect. It can be treated just like normal sick time off. If you require your other employees under normal circumstances when they're sick to use paid time off, use sick time, or take it unpaid, you can follow your standard procedures. It gets trickier when someone is being told to stay away from work. And that's where you get into, again, more of the morale issues perhaps than the legal issues. If you tell someone to stay home because they've engaged in high-risk activity, you're generally not legally required to pay someone for that time. And so from the morale standpoint, it's all over the board. We had a situation come up where someone said, we have an employee who was off in Vegas this week and posting on social media all the parties and events, this is of course before Vegas closed the casinos, that the person was at. And we deem that high risk activity. We want to put the person out and we don't want to pay the person. It's a little more reasonable than that to put someone out and say you're not going to be paid because that person put himself into a high risk activity. But generally, if someone's off because you believe they may pose a threat to your other workers, the law doesn't come in and say you have to pay that person. If employees are asking for time off, what we're generally recommending is ask why. If someone's saying, I want to be off because I'm afraid that coronavirus is ravaging society and I don't want to be exposed, you can tell that person they can ask for a leave of absence. That's not necessarily paid time. If someone's off because they've been subjected to a condition at the workplace that might not be safe, you might have a little more latitude for them. These, of course, can vary. Everything we've covered here has been very dynamic. It's changed over the last couple of days, and weeks ago, we might not have even contemplated it. So if you come across them, certainly reach out. You've got our contact information, others. Before I go, and we promised Tim we wouldn't extend too long, so again, I wanted to identify just some of the other key issues that we're seeing. One of those is the issue and the question that's come up over and over, hey, if something happens, or if somebody gets sick or was sick, do I have an obligation to report that, say, to OSHA or to other employees? The good news is your OSHA reporting requirements in these types of situations are very limited. If you have an employee who is on one of your job sites who tests positive, it's generally going to be considered an OSHA recordable, but not a reportable incident. If you're familiar with OSHA, certainly that'll make sense, and I don't have time to go through all that today. The only time something's going to be reportable to OSHA is generally going to be if somebody can show that he or she got infected at work and had symptoms that required hospitalization or one of the other types of treatment regimens that would be OSHA reportable. So it's generally not going to be something that's OSHA reportable. As far as announcing to your other employees, if you know of someone that was a high risk at a job site, we absolutely encourage notifying other employees. Now, there are medical information privacy laws that come into place, so it doesn't mean you go in and say, hey, everybody, Brian Kelly is sick, and here's what's wrong with him. But you put word out that we had somebody on site, that person, if the person tested positive, whatever it was, and just share generally the steps that were taken. As you'd expect, people are going to know immediately who was involved, and they don't need to get the details from there. Another question we're getting over and over is, hey, can I put somebody at the front door of my facility or on the edge of a job site with a forehead thermometer and take the temperature of everybody coming in? From a legal standpoint, you can. The medical experts would tell you it's not the greatest predictor of whether somebody is sick or at high risk, and it's not your time best spent. But from a legal standpoint, if it's something you want to do, you can. A week and a half ago, you couldn't have, because at least for employees, taking even just a temperature check was deemed a medical exam that couldn't be done without specific reason, as in you suspect that person to already be sick. But those rules are suspended in the event of a pandemic. Those of you who work with unions, you probably know that if you're going to start changing things, leave policies, pay practices, anything like that, you generally have a duty to bargain with the union before you implement them. There are exceptions to that, and plenty of people are arguing that when you have a global pandemic, that would create the type of exigent circumstance that can get past the duty to bargain. We still recommend, even if you're going to go that route, talking to the union and letting them know what you're going to do, at least to put them on notice before you roll it out, even if you don't bargain. We're not getting a lot of pushbacks from unions to the types of changes we're making here. Just a couple more. Require medical certification. We're getting that a lot too. Hey, can I require someone to give me a doctor's note before I come back to work? If you've got a good faith basis to believe that somebody may have been a danger because of their own illness or high risk activity, you can. You shouldn't be asking for more medical information than you absolutely need. So that type of medical information should be along the lines of something from a doctor that says this person can safely return to work around others. It shouldn't get into diagnosis, prognosis, that type of thing. And that gets into the last item there, that there is still a duty to maintain specific medical information as confidential. And I'm already hearing lawyers who are threatening to file claims over that, that there are breaches of medical privacy, and it's separate and apart from whether they were made to preserve safety. They're going to say those are individual rights that have been violated. So that is, in as quick a time as we can, and my apologies for going quickly, the primary issues that we're coming across. You'd imagine there are many other issues are coming up day to day, but these are the ones that either you or the people who are in the front lines for you ought to be issue spotting and running them by the people who are authorized in your organization to answer them, because answering these the wrong way, as I said, when we get past this era of this short period of we're all in this together, it is going to lead to legal claims, and as many as we can avoid, the better. So I appreciate everybody's time. If there are follow-up questions, everybody should have our contact information there. We deal with this stuff every day, and we're happy to help out however we may need. I think Tim mentioned he may tee it up for questions, and I'll stop talking now.
Yeah, thank you, Brian, and Chris, and Mark. Really appreciate it. I don't see any pending questions. There was a question about what the stance of organized labor has been with respect to this, and any kind of messaging regarding standing down or any such, don't work messaging, and there is no such thing. Actually, I just posted to the CEA COVID-19 Contractor Resources page the National Building Trades press release on the topic. They want to continue to work and continue to work safely for responsible contractors. I know that that's the case with the Cleveland Building Trades. Spoke with Dave Wondolowski yesterday and today. There are no trades that have told their members to stand down. They've all said they'll continue to work safely. And the apprenticeship classes are closed down, as are all classes, I think, across the board, but otherwise everyone continues to work. I don't see any questions. Again, thank you to Brian, Chris, and Mark for presenting Frantz Ward. If you have any questions, suggestions, or want to share resources with the other members, please email Glenn Shoemate, Kent Kreitzer, or me at CEA. It's important that the industry stay connected during this time rather than allowing ourselves to be isolated. So these meetings, I hope, will prove of some value to you. The next meeting to tune into is this Friday at 2:00 p.m., hosted by the AGC of America. You can register for that through the events section of the CEA website, ceacisp.org. Also, our safety director, Kent Kreitzer, is working on a safety-related web meeting, and we will announce when that is coming up by the end of the week. There is Looks like no comments that I see. George Palco, are you going to submit a comment or question? Well, we'll follow up with George afterward. Everyone else, thank you for joining us, and we will be in touch with future invitations, and see you soon. Take care of yourselves.
Tim, thank you for having us.
Thank you, everyone.